Hello, everyone. Good morning. It's quite strange to speak to somebody that I cannot actually see, but I can see this beautiful panel just on my screen. Welcome to the International Committee of the Beverly Hills Bar Association. For those that are not really aware about the committee is dedicated to international stuff, which does not mean that we dedicate our efforts to international treaties or trade or whatever. We just dedicate our core business as a committee to the development of international relationships between people and attorneys coming from all over the world. As you can see, a map just on my back, there are people coming from everywhere in the world, and we have a perfect example of that with the panel that is presenting this fantastic and beautiful panel today. We are obviously part of the Beverly Hills Bar Association, which means that everybody that wants to be part of our committee must be a member of the Beverly Hills Bar Association as well. So here on your screen, you can see the membership that have been just recently launched by the Beverly Hills Bar Association. So we have professional, sustainer, and economy. I think that there is also a particular membership fee for students, but if you want to inquire about that, you have.
I actually just double check. So the membership for students is free, and okay, it's on a sustainer level.
Fantastic. So good news. Students are free. And aside from that, you can also take advantage of a beautiful and fantastic initiative of the Beverly Hills Bar Association, which is the Beverly Hills Bar Association Virtual Office. The virtual office is a way that you can, have a virtual office, especially in these times, in these trying times during the COVID. Is much so important to have a virtual office where you can have your business online. And then last but not least, Beverly Hills Bar Association is also about networking. Networking means that obviously you can reach the Beverly Hills Bar Association dedicated website to the network, but also that you can join our committee in which really we network a lot. We just had our meeting yesterday. For those that have attended, they must have seen that we are keen on members. We want members to be active in our committee. We want members to propose new stuff, and we want members to grow up with us. Having said this, hoping that to see many of you that I cannot see now, but I hope to see many of you in person or during our next Zoom meeting that's going to take place every third Wednesday of the month. I am happy to introduce this beautiful panel, and in particular my co-chair Carla Pareja, that is the chair also of this beautiful panel, and I leave the word to Sara Fernandez, that is the moderator of the panel. Thank you for attending, everyone.
Thank you, Alessandra, and thank you to the International Committee of the Beverly Hills Bar Association for hosting this panel on force majeure and COVID-19, the international perspective. My name is Sara Fernandez. I will be moderating this panel. I am a transactional associate attorney at Super Lawler and Del Duca here in Los Angeles. In addition, I have worked at law firms in Santo Domingo, Dominican Republic, and in New York. And I'm very honored to introduce to you this very diverse panel. So first, let me start with Carla. Carla Pareja is a transactional lawyer admitted to practice law both in Spain, her home country, and in California. Carla's practice focuses in cross-border transactions with particular attention to Europe and Latin America. Carla is also an associate at Super Lawler and Del Duca, a boutique full-service law firm headquartered in Los Angeles. She received her law degree from Pompeu Fabra University in Barcelona and her LLM from the University of Southern California. We also have with us Andres Nieto. Andres is a partner at Krill Abogados in Mexico City. He specializes in banking and finance law, capital markets, and corporate law, including mergers and acquisitions. Andres is a leader in the Mexican transactional market and has been recognized as a leading attorney in fintech law in Mexico. He obtained his law degree at the Escuela Libre de Derecho and obtained an LLM degree at Columbia Law School. Ferran Escayola. Ferran is a corporate M&A partner in the Barcelona office of Garrigues and co-chairs the firm's U.S. desk. His practice focuses on mergers and acquisitions, acquisition finance, private equity, and general corporate and commercial law. Ferran primarily focuses on cross-border transactions with the U.S. and Latin America and has over 20 years of practice. He completed a specialization in European Union law, then obtained an LLM from Howard University and supplemented his studies at Harvard Law School. Finally, we have with us Haruka Kurokawa. Haruka is a member of the Japan and New York bars. She joined the Tokyo office of Nishimura and Asahi, where she focused on domestic and cross-border M&A transactions. After serving as counsel at Mitsubishi Corporation's New York office, Haruka is now based in Los Angeles, California, and provides legal advice to small and medium-sized business in Japan. She obtained her LLM from the University of Southern California. So to start deep diving into this interesting topic, I think that we can all agree that following the declaration of COVID-19 as a pandemic about 4 months ago, the term normal has forever changed for all of us. And as a token of that, look at us here exchanging ideas through the screens in our respective homes or offices. Since then, we have seen governments around the globe implement travel, movement, large gathering bans. We have seen restrictive interventions, such as the closure of non-essential businesses. So this pandemic, not only by virtue of the disease, but also of the unprecedented measures that have been taken to contain its spread, has affected global business activity in an extraordinary manner. And there is a public health crisis paralleled by an economic crisis. And one of the prominent implications is the inability of companies to fulfill contractual obligations. So force majeure clauses have taken center stage as they have proven fundamental in protecting players from the harsh consequences of contractual breaches resulting from this pandemic. So force majeure, which can be translated as superior force, will address events outside the control of parties to a contract that prevent one of those parties from performing. We will have clauses that aim to allocate this risk among the parties, and a well-drafted clause majeure clause will be very helpful in addressing these sort of situations, not only in the past, but even more now for the future. So although force majeure is not only addressed by local laws and jurisprudence, it is also dealt with in international treaties such as the UN Convention for the International Sale of Goods, the Vienna Convention, and by regional treaties. I'm confident that this panel will give us all a great overview of what's happening in the world around force majeure and COVID-19. So let's start with Carla. Carla, what do we think about force majeure clauses and related principles in the context of the United States?
Thank you, Sarah, for the introduction, and thank you, Ale, for your few words on the International Committee. As Sarah mentioned, force majeure is an event that is outside the control of the parties, and it is a contractual clause. But under common law, we also have the doctrines of doctrines of impossibility, impracticability, and frustration of purpose, which are non-contract-based defenses to non-performance. But we're going to see later when I deep dive into the common law principles that these doctrines have some limitations. So often, although these doctrines are available for parties in the United States, most parties will include the force majeure clause in their agreements, especially in contexts like the one we're living now with COVID-19. So let me start by explaining what force majeure clauses typically include, and then I'll discuss the common law principles. So on common law clauses, we're typically going to see things like what constitutes a force majeure event, what remedies parties have when this force majeure event takes place, and what parties must do to invoke force majeure. So starting by what constitutes force majeure, we're going to see typically language like acts of gods, floods, earthquakes, acts of terrorism, and things of that nature. But it's important to keep in mind that force majeure clauses are narrowly construed. So courts will only include events covered by the language in the force majeure clause. So in the context of COVID-19, we should not only have language like contagious virus, pandemic, disease, and things of that nature, but also language such as state of emergency, government action, and related language, because in the current context, a party's inability to perform may be due to these government actions in response of the pandemic rather than the pandemic itself, such as stay-at-home orders or closure of non-essential businesses and things of that nature. Also, it's important to keep in mind that casual language such as "and any other event outside the control of the parties" is not gonna work the way the way it may work in other contexts, because as I said, courts narrowly construe force majeure clauses. So unless the event that occurs is very similar to those listed on the force majeure clause, even though you have this casual language, courts will not interpret it broadly. So let's say that your force majeure clause has acts of terrorism and strikes, and then you are unable to perform because of COVID. A pandemic has nothing to do with acts of terrorism or strikes. So the casual language wouldn't necessarily be useful in this context. Then what remedies do parties have if a force majeure event occurs? So the remedies range from delay in performance, suspension in performance, or even excuse of performance entirely. And there is a very interesting case that's called Citrus Soap Company versus Speed Pros Manufacturing that I would have loved to go through it with you because it's really interesting, but for time purposes, I won't be able to do that. I added it on the written materials that we included on for this panel. So I encourage you to read it because it's the case that I found that is more similar to what we're living today. Obviously, we don't live pandemic contexts every day. So this case is in the context of the Spanish flu outbreak dated back in 1920. So it's quite old, but it exemplifies very well these remedies that parties may have when a force majeure event occurs. And then what must parties do to benefit from these force majeure clauses? Frequently, the force majeure clause will expressly require that the party unable to perform uses reasonable efforts to mitigate the effects of the force majeure event. And even if the force majeure clause doesn't expressly require it, it's advisable to do so because it's a good way of proving that performance was truly impossible. And then we're also often going to see language regarding notices around force majeure clauses. So the clause may require that a party expecting to not be able to perform notifies the other party. Sometimes there is going to be a specific timeline or certain means by which notice must be provided. And often also the party will have to specify the expected duration of the event. And failure to comply with these requirements may preclude a party from obtaining the force majeure protection. So it's important to go back to these provisions and follow them. Obviously, we're going to see instances in which the means by which notice must be provided are not specified in the force majeure clause. And then obviously we would just go to the notice provision of the agreement and follow the procedure there. So that's very briefly the introduction on force majeure clauses. Now let me talk to you a little bit about the common law principles. And you're going to see that even if you don't have a force majeure clause in your agreement, in the context of the United States, you can still rely on the common law defenses of impossibility, impracticability, and frustration of purpose. And it's important to keep in mind that states interpret these principles differently. So some states have more strict requirements than others. So I'm going to be speaking generally and making a couple of examples on some states, but keep in mind that these may vary state by state. So starting with impossibility, an example is that is going to show what kind of events courts normally find the impossibility doctrine to apply to. California courts tend to find impossibility in cases where one of the parties to the agreement dies or suffers incapacitation, which obviously makes performance impossible because this party no longer exists. When an item crucial to performance becomes destroyed for the same principle, and keeping in mind that if there is a reasonable substitution, the item probably should be substituted, but if there isn't one, then you may be able to claim impossibility. And then California courts also have found impossibility in cases in which parties sign an agreement and then a new law comes into effect that makes this performance illegal. That's another example on instances in which you can find impossibility. It's important to keep in mind that impossibility and impracticability are not defenses if these impossibility and impracticability are foreseeable. So also, performance must be truly impossible. So an event just causing a task to be more difficult will most likely not trigger the impossibility defense. So an example is, let's say party A digs a well for $5,000, says, I will dig a well, agrees to dig a well for $5,000. And while digging the well, discovers that the soil is far more rocky than expected. And the cost to this party doubles. That probably wouldn't trigger impossibility because simply a simple increase in price may not be enough for the impossibility defense to kick in. The performance must be truly impossible and truly burdensome. So with the principle of impracticability, only some states recognize it, and it is a supervening event that makes performance so difficult or expensive that it doesn't make sense for the parties to go through with the obligations they agreed on. And a good case exemplifying the impracticability defense is Mineral Parkland Company versus Howard. In this case, the court accepted the defense of impracticability where a party, let's call it Party A, agreed to use all the gravel available in Party B's land to construct a bridge between Party A and Party B's land. So Party A used all the gravel available in the surface of the land and started building the bridge, but it couldn't finish the bridge because there wasn't enough gravel available. So Party B said, well, you need to finish the bridge. And Party A said, well, I agreed to use all the gravel available and necessary in your land, but that's all you have. So I can't finish the construction of the bridge. And Party B said, you use the gravel available in the surface of the land, but not in the submerged gravel on my land. So when Party A evidence showed that it used all the gravel in the surface and that using the submerged gravel would have costed 10 to 12 times more than the removal of the surface gravel, the courts accepted the defense of impracticability. So impracticability is not a defense if the situation is not severe enough. In many business transactions, contract performance ends up being more costly than a party expected. And as I said, a mere increase in costs will most likely not trigger the impracticability defense. And then Section 2.615 of the UCC recognizes the principle of impracticability. And for those in the United States, you already know that the UCC governs contracts for the sale of goods. So if you have a sale of goods, you may be able to use the impracticability defense. And then to finalize, frustration of purpose. Under this doctrine, performance may be still possible, but there has been a change in circumstances that have made performance radically different to what was intended by the parties. So an example is Party A agrees to pay Party B to use Party B's seasonal seats at the Staples Center to watch a basketball game. And then the basketball game is canceled. Party A may be able to cancel the contract under the frustration of purpose doctrine, because even though Party A can still go to the Staples Center and sit on Party B's seasonal seats, the purpose is frustrated. Party A wanted to watch the basketball game, and the basketball game has been canceled. So the purpose of the contract is no longer what the parties bargained for. So to recap, if you have a force majeure clause, great. Make sure if you're drafting one, it's very specific and very tailored to your client situation. If you don't have a force majeure clause in a contract, check if a common law doctrines apply. If your agreement is for the sale of goods, check if UCC Article 2 may apply. And also, my colleagues will speak about other international treatises and mechanisms in place that can be very helpful for international relationships, for cross-border deals. An example is, as Sarah mentioned initially, the United Nations Convention on Contracts for the International Sale of Goods, which governs contracts for the sale of commercial goods between parties in different countries. So that could also become helpful. And in M&A agreements, you may have a material adverse change clause that I believe my colleague Farhan is going to speak a little bit more about. And it's different to the force majeure clause, obviously, because force majeure speaks as to the inability to perform. So the COVID-19 outbreak may impede a party from being able to carry out its contractual obligations. While in the context of the material adverse change clause, the COVID outbreak may have now had a material adverse impact on the target. So the acquirer may no longer want to go through with its obligations, and if it has a material adverse change clause, it will certainly help. And keep in mind that the International Committee issues a magazine twice a year. I prepared an article on a case involving Victoria's Secret and the material adverse change clauses. So you should be able to see it on the next issuance of our magazine.
Thanks, Carla. And to wrap up your presentation, can you tell us a bit about how the force majeure clause and the common law principles work together? Are they exclusive or do they complement each other?
So that's a very good question that I encounter very often, and it differs from jurisdiction to jurisdiction. For example, New York and Texas construe force majeure clauses very narrowly. So the inclusion of a force majeure clause may preclude the parties from later asserting impossibility. And it actually has happened. Courts in these two states have prevented parties from invoking impossibility where a force majeure event was foreseeable at the time of entering into the agreement. And the parties decided not to include these events as one of the force majeure events. So it may be detrimental to later trying to invoke some of these principles. And it will obviously be on a case-by-case basis.
Thank you, Carla. So moving on to other parts of the world, Andres, can you tell us your thoughts on this from a civil law perspective, and particularly a Mexican perspective?
Are we?
Sorry, I was just taking off the mute button. Thank you very much to the International Committee of the Beverly Hills Bar Association for the kind invitation to participate in this event with my fellow panelists. As Sarah mentioned, I will try to cover some key features of force majeure in the Latin America region, obviously particularly in Mexico, my home country, and to make some extensions of which Carla has just mentioned about how this force majeure issue is regulated in common law countries. I would also mention some of the definition and the elements of the force majeure figure law in civil countries. Some of the questions that you may have to ask yourself if you are facing some of these problems, and at the end a recommendation to include always, or try to include always in your contracts, particularly in the cross-border transactions, a force majeure clause that it's particularly tailored to the transaction you're involved in. So there is an alleged difference in the civil, in the way that the force majeure is treated in common and civil law jurisdiction. While most civil codes make provisions for force majeure events, as Carla mentioned, at common law, the force majeure is not a specific term of art that is defined by statute. Thus, aside from the common law principles that were explained by Carla, in contracting law, no force majeure provision will be implied in the absence of a specific contractual provision. The extent to which the parties deal with unforeseen events will be defined in the contract between them. That's a difference, because in civil law countries, we do have some statutory provisions that covers the force majeure in case you did not include anything in your contract. Some of the advantages that the common law has over the civil codes or civil law countries is that the parties are bound by the contractual routes they choose to adopt. There is, therefore, I guess, a less risk of potential overlap with the provisions of the civil codes that might apply in a specific transaction. So force majeure it is always recommended that you particularly check in any specific country in which your contract or transactions will operate, if there is anything that the internal local civil or commercial code mentions about this, in order to avoid this overlap between what you include as a provision, contractual provision, or what is specifically mentioned in the statute. In Latin America region and in Mexico, many of the civil codes in the region states that no one is bound in a force majeure case except when you has given cause or contributed to it, or when you have expressly accepted that responsibility, or when the law particularly imposes it. Even though it's not particularly defined by statute, at least not in Mexico, the court has defined or made some definition of what we have to understand by a force majeure event, and which are the elements. And they have defined it as the occurrence of an event or circumstance that prevents or impedes a party from performing one or more of its contractual obligations under the contract, if and to the extent that the party affected by the impediment proves that such impediment is beyond its reasonable control, that it could not reasonably have been foreseen at the time of the execution of the agreement or the contract, and that the effect of the impediment could not reasonably have been avoided or overcome by the affected party. In civil law countries, aside from the force majeure provisions, we do also have what it has been named as a unpredictability theory, or the rebus sic stantibus clause. This unpredictability theory postulates that in the event of an extraordinary and unpredictable event that cause an economic imbalance among the agreed benefits of a contract, making the fulfillment of one's obligation more difficult or burdensome or onerous, the affected party may request the modification of the contract to restate the balance of obligations agreed within the contract. Which are the main differences between force majeure and this rebus sic stantibus clause? In the case of the force majeure event, it relates to an event that prevent or cause the absolute impossibility to comply with the obligation. While in the rebus sic stantibus, you are facing an event that has made that the obligation it's more onerous or more burdensome to comply with. Other difference is that the force majeure can apply to all type of obligations, whether are civil or commercial or administrative. In the case of the rebus sic stantibus clause, this will only apply in certain civil contracts, particularly those that are complied with during a specific term. And the other difference between these two figures is that in the force majeure exempts the debtor from the responsibility for comply with the obligation, while in the unpredictability theory, you can seek the modification of the economic conditions of the contract, or, if such a case, to request the early termination of that contract in particular. As we have seen, there's a very, I mean, it is not easy just to decide whether we are facing or not a force majeure event. So what should we do if we are facing this problem? There are several questions that we have to ask ourselves. And some of these questions, in order to better assess what would be the consequences, are the following. Is what type of a contract do I have? Or what is my obligation under the contract? What is the applicable law to the contract? What is the applicable jurisdiction? When did I sign the contract? Are there any provisions in the contract that may exempt you from liability? Is there any case of force majeure clause in the contract? What are the requirements set forth in the force majeure provisions? Do I comply with such requirements? Am I unable to fulfill my contractual obligations because of this alleged force majeure event? What makes it impossible for me to comply with? Is it out of my control? Do I have any insurance linked to my contract? The jurisdiction under which the contract is regulated has a statutory provision related to the force majeure or unpredictability theory. The conditions under which I signed the contract change substantially on the occasion of the event. What are the procedures set forth in the contract that may be applicable to the request of the suspension, modification, or termination of my obligations? Since there is a lot of uncertainty of what would happen in a contractual case or in a cross-border transaction, it is always recommended to have a very particularly or tailor-made force majeure clause. For this purpose, some international organization has the International Chamber of Commerce has prepared a draft or a force majeure model clause that it is recommended to be included in the agreements. As Carla mentioned, and probably Ferran is going to talk more about this, you have to obviously differentiate what type of contract are you going to sign and which is the provision that you're going to include. But if you're interested in, you can log into the webpage of the ICC and look for these force majeure clauses, which include very particularly elements. It defines what a force majeure event is. It deals also with the probable non-performance by third parties of the transaction. I mean, what would happen if a third party does not comply? That makes that one of the parties of the agreement does not comply with its obligation. It lists also some examples of force majeure events. How is the process of the notification of a force majeure event in case it happened? What would be the consequences? What would be the remedies available? What happened if this is just a temporary impediment? One thing that Carla mentioned, which is very important as well, is the duty to mitigate. I mean, the duty of the affected party to make all reasonable measures to limit the effects in case of a force majeure event. What will be the causes of the probable early termination of the contracts? And what happened in a case of an unjust enrichment, which is more or less covered by this unpredictability theory. So this is, in a nutshell, what are the key figures of the force majeure in Latin American countries or in civil law countries, and some of the recommendations in a cross-border transaction. I'll be more than happy to answer any particularly question or to contribute to the discussion with the other panelists. Thank you so much.
Thank you, Andres, and thank you to our attendees who are asking questions in the Q&A box. We'll go through them at the end, depending on how much time we have. So, Ferran, what can you tell us about the European approach, and particularly the Spanish approach to force majeure?
Well, thank you, Sarah, and thank you all for joining us today. Actually, Mexico and Spain have similar roots in terms of elaboration of their civil code. So I apologize in advance because some of the terms that I'm going to use have been already raised by Andres. But to address the situation in the European Union, in Spain in particular, we need to remind that in the European Union, we cohabit with common law principles applicable to England, Wales, and Ireland mostly, and with civil law principles that are applied to almost everywhere else, France, Germany, Spain, and the like. Also apply in Mexico, as we've seen, and probably will be told later on that also apply in Japan. Civil law systems are heavily codified, and local laws and regulations predominate generally over case law interpretation, as a difference with common law. In addition, in the European case, you have European regulations, directives that have to be transposed into national laws within certain time periods, lower rank regulations, and all of those affect nowadays the interpretation of legal situations arising out of COVID-19. And the effects are different in every country. Because unfortunately, after China and Italy, Spain was the third country to face the impact of the pandemic, and now we are still struggling to get out of it. And hopefully we will anytime soon. So in my 10 minutes, I won't be able to walk you guys through the specifics of each country, but what I can do is to describe the three most used legal tools that civil law countries are using to renegotiate, extend, ask for a suspension, excuse performance, terminate, or even avoid contract liability as a consequence of their inability to perform in commercial contracts. Again, that analysis will have to be made on a case-by-case basis, on a European Union member case basis, and particularly for what it refers to consumer laws that go beyond the scope of this presentation. So the three most used legal tools are the first, the definition of the pandemic as force majeure and its consequences over contracts. Mostly in Spain and most European countries, force majeure event has been used to extend, renegotiate, or terminate contracts. What our statutes do not say is what constitutes a force majeure. What our statutes say is the consequences, or deal is with the consequences of a force majeure event that I will explain later on. The second is the physical, what is called physical impossibility, that helps to renegotiate or to terminate obligations, and that it's common in countries like France, Italy, and particularly in Switzerland. It's not full member of the European Union, but they still have also this way out to renegotiate contracts under COVID. And the final one is the application of what Andres touched base upon, which is the rebus sic extensibus, the things thus standing, that would be the translation doctrine, that also helps to renegotiate or to terminate agreements as he advanced. So one of the backups that we have is that when parties into an agreement do neither state the existence of a force majeure event, or what constitutes force majeure, or they don't deal with their consequences, the Spanish Civil Code applies by default. And the article of the Spanish Civil Code that applies by default, what it says is, talks about the consequences of when there is a force majeure event that has to be agreed by the court on the existence of a force majeure event. What are the consequences? And it says that no person shall be liable for an event that could have not been predicted, or if predictable, and that's irrelevant, was unavoidable, except in this scenario, which the liability is explicitly foreseen under the applicable regulation. So you have particular regulation in labor laws, for instance, that can readdress what is a force majeure, or what are the consequences of force majeure event, or is declared as part of the obligations of the party involved. So that meaning that in the agreement, you can state what is going to constitute the event of force majeure, what are the consequences for the parties, and what are the consequences for the agreement itself, whether it raises to termination or suspension. So in Spain, and in most countries affected by COVID-19, the pandemic has been recognized as an event of force majeure, not only in contracts, but also in regulations affecting trade, consumer laws, labor relations, even bankruptcy proceedings, and in many others. And it has also served as an excuse to try to get into renegotiations of contracts, sometimes taking an unfair advantage of the situation of the COVID that I will discuss later on. So the application of the civil code in the force majeure consequences in terms of liability has led room for interpretation on whether any breaching party under COVID-19 circumstance can be automatically freed from any liability, and the answer is no. In Spain, the backlog that gives the civil code is not enough to interpret whether any particular contract is subject to an excuse of liability, and that will depend on the type of the agreement, on the specific regulation applicable to the particular contract, the case law applicable in similar cases. We heard about the 1920 N1H1 flu pandemic, the so-called Spanish flu, but also in 2009 regarding the SARS episode. Those are the two only situations where our courts have described whether force majeure applies or not in the case of pandemics. Moving to physical impossibility to perform, as I said, is applicable also in France and in Switzerland. The physical impossibility to execute an agreement in Spain unfolds into two types of situations. The first one is when there is an obligation of delivery in a specific item that cannot be, at no fault of the debtor, be performed, and therefore the obligation is extinguished. And the second one is when the debtor may be also released from its obligations under contract, when this is legally or physically impossible to fulfill the obligation. That's also a regulation in the Spanish Civil Code. So what these two articles of the Spanish Civil Code bring to us is the legal basis to defend termination of the obligations or to open discussions for extension of certain agreements that have been also used during the pandemic. There are several examples of that. such as during the imposed lockdown, contracts that could not be fulfilled because of the legal restriction or due to lack of delivery because of the mobility restrictions imposed by law would meet the two criteria, the impossibility of delivery and the impossibility of, or the legal restriction that makes impossible the fulfillment of the obligation. Nevertheless, I think it's worth saying that the existence of a force majeure event or the theory of physical impossibility sometimes sits awkwardly with the fact that some material or contractual obligations to deliver remain possible. And one of the cases that we've seen more controversial is in M&A transactions or in services agreement is the ability to pay for those services or the ability to pay for the price of the shares or assets sold. This ability is a generic obligation, and therefore no one can be prevented from honoring the contract by applying these two articles. And this is something that some players in our economic system have been using to avoid payments. The fact that the payment was impossible. So payment is not impossible because it's not a lack of delivery, or there is no legal restriction to receive payment. And I say that because not only in Spain, but also in other countries in the European Union and outside, what's the consequence of the pandemic is that the uncertainty of the economic consequences that this can bring to the companies has inspired many companies to apply what it's called cash preservation policies, taking unfair advantage of the pandemic and foreseeing the economic crisis that may follow it. And you will see that as a consequence of that kind of preservation policies, the Spanish courts now are very busy. I'll tell you about it at the end of my remarks. And the last tool I want to describe is a little bit more for the particularities that it has in Spain and in some other civil law countries, is the rebus sic extensibus, the things thus standing doctrine that is developed also not only in civil law countries, but also in international treaties and in many national courts, and was born, as Andres said, to reestablish the balance between obligations of the parties in a contract, essentially based on what you guys call the principle of fairness, right? So the doctrine enables obligations and contracts to be reviewed when, due to supervening circumstances, the economic balance between the parties is broken. As Andres talked about that, so it's the same in Spain. However, the difference country by country is that in the case of the Spanish courts, the Spanish Supreme Court has always opted for a very conservative application of this rule, and has required that the following three situations occur, which makes the application of the rebus sic extensibus doctrine really tough. The first one is that it has to be an extraordinary alteration of circumstances between the completion of the agreement and the compliance of the obligations of the agreement. The alteration must have occurred due to the appearance of supervening circumstances that are radically unexpected at the time the contract was completed, and this probably is one of the ones that COVID-19 would comply with. And the third one is that the alteration must cause a huge disproportion beyond all calculation as regards of the economic provisions of the contract, and greatly increasing the burden of the cost of the obligations of one of the parties. And this is something that doesn't occur, or it's not that easy to evidence in occurring in a commercial relationship. So these three positions have been set by the Spanish Supreme Court as a tool to interpret and apply the rebus sic extensibus doctrine, and their application needs to be carefully and thoroughly studied to avoid incentives to opportunistic breaches of contract that may apply this doctrine as a defense. For for instance, and you guys talk about this before, in an M&A transaction, the closure of financial markets as a consequence of COVID-19 could be considered under the rebus sic extantibus, but there is no way that, for instance, a more expensive access to financing to close a transaction would not be considered. That would not be considered as a subject to apply this doctrine. The same happens with in M&A transactions where the COVID-19 outbreak happened in the interim period between signing and closing, and that affected the valuation of the underlying asset or the shares. What we have seen in Spain is that this is not an excuse to reopen for negotiation or to lower the value or even to avoid payment for those shares if the transaction was signed prior to the outbreak or prior to the force majeure situation. And to fit on a schedule, what can we expect moving forward? And I just want to touch base on a couple of issues that are relevant in Spain. First of all, if no private agreements are reached between the parties, the applicability of the three theories that I just have explained has to be brought before a court or an arbitration panel. So the lack of automatism applying these doctrines will derive in a huge amount of claims after COVID and once the courts are full back on track. For instance, currently Spain has more than 75,000 judicial cases waiting for a decision at lower courts, combining COVID-19 related criminal, labor, civil, and commercial claims. And what this is telling you is that if you don't have a very strong position contractually, or you don't have negotiated very strong and clear to interpret force majeure clause, or you don't have a clear picture on whether the rebus sic extantibus doctrine can be applicable to your particular case, it's much better to not get into a judicial proceeding and to try to find out a way to extend or suspend or refinance your obligations, because going the other way around will lead into mostly unnecessary expense, a lot of time, and overall it will bring you to something that some voices have been raised recently on the Supreme Court, which is we are going to be so work overloaded with COVID-19 related claims that probably the traditionally upheld theory of agreements must be kept, that is this Latin pacta sunt servanda, which probably is arguably the oldest principle of civil law and international private law. Maybe this has to be reconsidered to deal with the COVID-19 consequences in contracts, and that could be an opening to faster but not fairer resolution of cases in Spain.
Thank you so
We'll
much.
see how all this develops. Sorry?
Thank you so much, Ferran. We're running a little bit low on time, so I think we should transition to Haruka. So Haruka, what can you tell us about Japan and the force majeure clause?
Okay. Thank you, Sarah. Let me start by mentioning the basic the basic system of law in Japan very quickly, and then go to the contract with force majeure clause, and then cover the contract without force majeure clause. Same as Spain and other European countries, Japan adopts the civil law system. The written statutes will be the primary source of law, and the role of court is to establish the fact and apply remedies from the statutes and the contract between the parties. Now, actually, there is no statutory provisions providing for the so-called force majeure in Japanese law, But the civil court and other statutes still provide other solutions to release the non-performing party if the non-performance is due to the effect of the COVID-19. I will explain this in more detail later. But let me first examine the cases in which the party had included the force majeure clause in their contract. For many international transactions and large size, middle size transactions in Japan, I believe the party likely to include those clauses. But though I don't believe that they took enough care to examine the language used there. And of course, under the principle of freedom of contract, if the force majeure clause is there, it is enforceable in Japan. The Japanese court's interpretation of the contract tend to be fairly strict, maybe not as strict as those in the US, but still the court will focuses mainly primarily on the explicit language there. Therefore, whether or not the COVID-19 qualifies as a force majeure event really depends on how the party drafted the clause. And even if the COVID-19 qualifies as a force majeure event, the party may still have to show that they took reasonable steps to avoid the effect of COVID-19 and the causal link between the COVID-19 and its non-performance, which I will cover very soon for those requirements. But of course, if the party use language that we don't have to take reasonable steps to avoid the situation, then the contract clause will apply first. So next, let me examine the cases in which the party had not included the force majeure clause, or even they had, the court determines that the COVID-19 pandemic does not qualify as a force majeure event under the specific language provided. As I mentioned earlier, there is still a chance for non-performing party to be protected. For example, in case a party claims damages against the counterparty for non-performance, the accused party can use the idea of force majeure as its defense. This is because the civil court in Japan requires negligence to hold a party liable. And if the party can successfully attribute its non-performance due to a force majeure event, then it means there was no negligence on its part. The key then is to determine whether or not the party was negligent. Actually, there is an exemption from this negligence requirement, which is monetary obligation, like payment obligation. The party cannot be waived from liability even though there was no negligence on its part. So to prove the absence of negligence, the non-performing party has to establish the following four conditions. One, the existence of obstacle beyond its control. Two, such obstacle could not have been foreseen at the time of signing of the contract. And three, the party took all reasonable steps to avoid or mitigate the effect of those obstacles but could not do so. And the last, the causal link between the obstacle and non-performance. In the case of COVID-19, the first condition is easy to demonstrate. It's beyond parties' control. But the second, third, and fourth conditions may be more difficult to prove. For the second one, the enforceability of the party, it is unclear if the court would deem the COVID-19 as an unforeseeable obstacle, since we have had other pandemic before in the history, and other forms of coronavirus have always existed. So that might be questionable. Of course, if the contract had been signed after the COVID-19 pandemic started, then the court is more likely to find that the obstacle was foreseeable. For the last two conditions, the party's inability to avoid the effect of COVID-19 and the causal link between the COVID-19 and its non-performance, we have to consider the specific situation in Japan carefully. Compared to those in other countries, the COVID-19 situation in Japan is not as severe. And indeed, the Japanese government never issued orders like stay at home or closure of business. They merely advised, not ordered, citizens to stay at home and certain type of business to close. Okay. The absence of government orders could lead the court to determine that the party could still have performed their obligation despite effect of the COVID-19. So, inclusion, given the importance of the contract language in Japan, if contract provides a force majeure clause that covers pandemic or like government advice of closure of business, then the performing party can more likely defend itself. And this is the only way for payment obligators to be waived from their liability. On the other hand, if the contract does not provide such language, then the non-performing party has to rely on the statutes for protection, but establishing its lack of negligence may be challenging. And this is only available for non-payment obligators. I think that's all from me. Thank you.
Thank you so much, Harika, and thank you to all our attendees and our panelists for this interesting and stimulating conversation. I'm very sorry it went a little bit over schedule, but feel free to message our panelists on LinkedIn or to channel your questions through the International Committee, and I'm sure they'll be happy to discuss further about the intricacies of force majeure. Thank you, everyone. Alessandra, I don't know if you want to say a couple of words to close.
Yeah, I just want to tell you that you were fantastic, of course. You were able to give a very useful overview on all the jurisdiction involved, and really thank you so much on behalf of our committee to having been part of this wonderful program. Thank you so much.
Thank you, everyone.
Bye-bye.
Bye.
Thank you, bye.